Background checks are a crucial tool for helping employers avoid liability for negligent hiring, but navigating the federal, state, and local laws to stay compliant is a huge task. The background check is not to tell you to hire, but who not to hire. So if you don't do background checks at all, or you don't do them correctly, sooner or later you're likely to become the defendant in a lawsuit. Here are 7 tips that employers should keep in mind during the hiring process. Number 1, check for potential issues from the start. Carefully review the application. Did the applicant sign the application, the background release, and identify any past employers and explain to you any employment gaps? Number 2, use an accredited background screening company. Not all background screening firms are created equally. In 2010, the Professional Background Screening Association created the Background Screening Agency Accreditation Program. According to their website, the accredited companies are governed by a strict and thorough set of professional standards. The accreditation has widely become a recognized seal of approval, bringing national recognition to the best employment screening organizations in the country. Number 3, you should simplify your screening process and make sure that the screening system that you're using is intuitive and user-friendly. The applicant tracking system is initiated through an ATS. This system typically automates every step of the process from recruiting to hiring and is a useful and affordable tool to look into if you're not already using one. Number 4, beware of FCRA class action lawsuits. The Fair Credit Reporting Act regulates employment screening and outlines consent, disclosure, and notice requirements for employers that use third parties to conduct any background checks. The FCRA compliance involves a lot, and for good reason. We want to protect the public, but that means that FCRA compliance is an integral part of the hiring process. Many times it's overlooked negligently by employers and non-PBSA accredited screening companies alike. Under the FCRA, claimants can seek damages for up to $1,000 a person, and that can add up quickly. Class action participants have penalties for the FCRA violations, such as failing to use FCRA forms or providing applicants with proper notice before making an adverse decision. Millions and millions of dollars have been paid out because compliance errors, and so don't overlook this crucial step of compliance. Number 5, you can understand the limits in the credit salary history inquiries. Don't use credit reports across the board. Some states prohibit the use of credit reports for hiring decisions, and others have very specific rules on how employers can obtain such reports. Employers should be able to show the business necessity of the job relevance of credit history information if they're running a credit report. Number 6, understand the limits on the credit salary history inquiries. Employers should be aware of all state and local laws around salary history inquiries. Determining a new hire's pay based on prior compensation can create legal issues for employers and perpetuate gender discrimination and other forms of salary bias. In short, compliance during the hiring and background screening process can feel complicated, but don't worry, we have clients in your area. Give us a call anytime, and we'd love to chat with you more.
Now that's validation.